Hi, folks. This is Tim at Love Change Grow, and this week's post is going to be mainly a video. And there will probably be two or three videos, but I was asked to kind of present some information about the Involuntary Treatment Act, or the involuntary detainment or commitment kind of process. In my experience, for 25 years, I was an involuntary treatment officer in Washington State. And during that time, I made many presentations to colleagues as for training, also to NAMI groups, the National Alliance for the Mentally Ill, to law enforcement, first responder types, and also just the families and even case managers and community support groups, including things like schools, counselors, and what have you. Anyway, so some of this is perhaps a little dated because I did this about 20 years ago. I was doing this pretty regularly. But I believe the concepts still hold, still operate. Some of the procedures and processes may change a bit. And so with that, it's most important to contact the local agency or group of folks that are doing the involuntary evaluations. And that's useful for a couple reasons. One is to get an idea of how that actual community practice and what the resources and services are. And you can think of it that basically each community has different resources, different relationships, and different ways of doing things. And so it's best to go there and get a consult, get information, ask questions on how the involuntary process works. And this is just general information of some concepts and how I taught this as a statewide trainer at one time, and what I think is valuable. Now, every commitment officer has different experiences and things like that. I used to run a team and have worked with 4 or 5 teams throughout my career, and there are always little different things to that some communities paid more emphasis on or had kind of a bias or agenda because of resources or the lack of resources. So just be aware of that. And so this information is really to just provide information to help yourself, your family members. Perhaps it's useful for communities to have some of this information. And it's two-sided. One is to protect the persons that is in need, and the other sense is to get them the services they need or they may not need. So it can work both ways. So there's each state has different rules and different laws or statutes and different ways of how it's prescribed to do this. And like in California, it's called, I believe, the 50-51 evaluation, and I believe it's done mainly in the ERs and with the ER hospital staff. I'm not for sure about that. Some places it involves police and a law enforcement officer and our county sheriff and a family member. Other places it's just one person that does that, a psychiatrist or a psychologist. In Florida, it's called the Baker Act. So just be mindful, do a little bit of research, and ask a lot of questions. This is in part why I'm doing this, is because a lot of mental health, and especially the involuntary commitment, is in a black box. Most people don't have access to how that works, or seeing how that works, or how that process happens. So again, this is based on my experience, my thoughts, my knowledge of 25 years of doing this. So I'm going to post a picture on the blog side. On this post, which is this thing here, and I know you probably won't be able to see it, but it will be posted. So it's a reference. It's something I developed years ago, and so it's called, the top is ITA investigations. And so this video is to just present some general concepts, the big picture, so that you kind of have an idea of where things have come together. And the ITA process is I found it very interesting, and that's why I kind of pursued a career in that. Basically, you have a person in crisis or alleged to be in crisis. You have the clinical kind of piece, where are all the pieces, what are the criteria to that a person is committed under. And then you have the community in which this all happens. And then you also have the law, because it's a civil, in Washington State, it's a civil legal proceeding. And so in that's different than criminal proceedings here. And so let me jump into it. So in the upper left-hand corner, so right under the first line under ITA investigations, is individual autonomy and civil rights. So the thought is that in our country, everybody has the ability to pursue life, liberty, and happiness, and each person has an individual right to live their life how they see fit, and that is protected under the Bill of Rights and so forth in the Constitution of the United States. And so that's where the whole thing, you can live your life however you see fit. Now then the rub comes up, is that in life you can do whatever you want to do, as long as you're being safe, as long as you're not presenting undue burden on someone else or their property, and things like that. So that's where on the other end you have the legal issues, and the legal issues are kind of subtle, but I will tease a bunch of that out later. But just think, on the other hand, when does a person lose their rights or can be contained? Under what conditions are those? And so then that brings in the middle piece, which is public safety. And public safety is if a person's in public, basically the idea is in your own castle, your own house, you can do whatever you want, it's behind closed doors and all that, and as long as you're not perhaps being too loud or conducting yourself in an illegal manner, selling drugs or something like that, there's no reason for anybody to come into your home to evaluate you. So I missed this piece, is you'll see parens patriae. And parens patriae is the idea is that if you cannot take care of yourself, basically, then the state has the has the responsibility to care or take care of you if you're unable to do so. And so that gives basically the authority of the state under that condition is if you are deemed unable to take care of yourself, they step in and will take care of you. And that's sort of the state's duty or responsibility to do that if a person is not able to take care of themselves. So that's that line of individual autonomy, civil rights, public safety, and parens patriae. Under that is a second role, or the third role, I guess, is where basically this is where the involuntary treatment officer, this is what they do, is basically on one hand, we do consumer advocacy. If a person isn't able to advocate for themselves, we try to make something happen for them. And that can be advocacy in that. Here's a way to think about this whole thing. Involuntary treatment officers are like home plate umpires and of the game of crisis mental health. And if a person is in such a crisis, they're not able to access what they need, I, as the evaluator, can knock on doors and open up doors that nobody else can. And so it's like that part of my job is to access resources that a person either doesn't know, isn't capable of, doesn't have access to. And so we're kind of like in a lot of ways, the last resort or last option for a person, that we can magically open or get access to services that nobody else can. And so then on the other side, you have the legal issues. When can I force a person or contain a person to a involuntary inpatient mental health unit? And what is the legal evidence to do so? And how does that work? And I might as well get into this right now, is that we think of it as a legal thing, and there's a big legal umbrella, but there's parts of the umbrella. So oftentimes when people think about legal, they think about the criminal law. And merely the criminal law is that, hey, if you break the law, then you can get cited or fined, or you can go to jail. That's all that means, is that you've broken the law and gone to jail. However, on the civil mental health detainment side, on the civil side, it is marriage, adoption, divorce, bankruptcy kind of stuff, which isn't criminal, but it's a matter of civil law, of how relationships work in the society or community. And so mental health is this very small piece where the laws are laid out that there are certain criteria that have to be met before a person can be involuntarily detained. So that's that piece, and we'll dive into that probably in the second video. We'll really tease that apart. So then in the middle, you have the clinical presentation, acuity, diagnosis, medications, and available treatment options. So the central piece of the involuntary treatment investigations is that you basically match what is the person experiencing and presenting, and what is the appropriate intervention, the appropriate treatment. And so a lot of the meat and potatoes is seemingly the clinical presentations. What's the diagnosis, or seemingly to be the diagnostic impression? The clinical formulation. Why is this happening now? And what's the appropriate intervention? In one of my other posts, I kind of talk about diagnosis, clinical intervention, and treatment, and you can go and look at that, and that's sort of that piece. And so, as a home plate umpire, it's investigating, the person's protecting their civil rights, trying to assess how able are they to advocate and get resources for themselves. You have the clinical piece, where is what is actually happening? Does this fit under mental health? Or is it something else? And then you have the legal issues, is that is there sufficient cause or evidence to detain a person? And then this third line here is crisis in the community, or stabilization in the community, appropriate clinical therapeutic interventions, and evidence to detain. So quickly, stabilization in the community. Let me then point out this line that's sort of a diagonal that goes from outpatient, voluntary hospitalization, involuntary hospitalization. So you can look at all this as a spectrum from outpatient to inpatient. And so if a person is coming in and we're kind of figuring out, oh, okay, this can be dealt with at an outpatient level. And there's all kinds of a spectrum of that. Outpatient can be go see your therapist, case manager, and talk with them. They'll help you figure this out. You're engaged, you are responsible, you're voluntary. I'm begging you to go and do this, because it seems like to me, if you don't, it's going to continue or escalate, and ideally we don't want that to happen. Now, as a voluntary person, I can encourage you, I can recommend, I can beg you to deal with this, but because you kind of understand the situation, it's ultimately your choice to do so or not. Now, the issue is, if I'm seeing you for the third time this week or in 2 weeks, and I've said, go talk to your therapist, your case manager, go see your psychiatrist, get back on meds and stuff, and now I'm seeing you for the third time, well, I'm going to say, look, that hasn't worked, so we're going to ramp this up a bit. So some of the services on the voluntary side would be things like detox, a crisis triage, a crisis respite bed, or a house kind of, or program kind of thing. And the whole idea is it's therapeutic. We want to stabilize you in the environment in which you live. Mostly, whether that's at home or a few days in a crisis respite placement kind of thing. And so with the belief that, hey, let's take care of this. If you don't take care of this, we'll have to proceed towards the more intensive kind of piece. So I think you get that. So as we get around the voluntary hospitalization kind of idea, is that, hey, you need more than outpatient. Look, I think there's a good reason for you to be in the hospital, to get stabilized on meds, or perhaps just like things are just off the rails, and you seem to understand that and acknowledge, yeah, I need some help, but oftentimes what happens is a person isn't able to really make their case. So ideally, the ER doc, the ER social worker, or even the crisis respite house or crisis respite bed is saying, hey, look, we need more help here. The person's willing to go in voluntarily. It's more of a matter of stabilization and a tad bit of safety, because we need to get this figured out. And it's more on kind of a humanitarian grounds, and the person recognizes they need this. So sometimes as an involuntary treatment person, I can really push that door open. If there's a bed available, hey, I'm pushing this door open and I'm arguing for the case that let's support this person because they need the stabilization. Let's not wait until it's just a disaster. And the person's willing to do that, so let's get them in. It's going to be appropriate. And then as we move towards the involuntary hospitalization, we'll get into the imminence and the evidence and the safety much more in detail in the next video, because I don't want this one to go hours. I used to do this and it would take 6-8 hours to go through this whole package, and we're not doing that. So back to the stabilization in the community. As I'm the person in the middle of the night at 2 o'clock in the morning, and the person gets brought in by family or the police, I'm there to try to figure out, what's clinically happening and what's the appropriate interventions that are going to stabilize them, support them, so the wheels don't come off the bus. So let's go over under the evidence to detain. And so a lot of people get confused, and there's a fine line between, hey, I have an opinion that this person needs to be in the hospital or doesn't need to be in the hospital. So what is the evidence? And I will often go into the ER, and I may have reports from the police, statements from family members, reports from the crisis line, and all kinds of information. And that's just information. And that is an opinion or a speculation, okay? The alleged thing is merely reports, and it doesn't become evidence until evidence happens in court, so to speak. And really the prosecutor is the one that determines what is the evidence to be provided, or what is the information to be provided. And once that information is presented to the judge, or in the case of a jury trial, to the jury, once that information is presented and heard by the judge's ears, that becomes evidence, okay? Up until then, it's not. And so there is also things such as expert witnesses, and certainly different witnesses or people that come in to testify have different weights. And so probably the most weighty in my experience of having also been a court liaison, who is the mental health liaison in the whole court processing of petitioning and getting witnesses in and testifying and stuff like that. My experience has been that the judges or commissioners that sit and hear the mental health cases, they are very reasonable and compassionate, and they really do want what's best for the individual and the community. And you have to make, basically the whole thing is to make a case for, hey, this person really would benefit from a stay in the hospital. But it really doesn't become evidence until a person testifies. And certainly, um, family members who testify in support of having their loved one in the hospital, it makes a big impression on the court commissioner or the judge. Um, Certainly, police officers, law enforcement officers, they get a fair amount of weight because they can testify to, hey, this is a public safety matter, and we're trying to both protect the community and help the person get access. And then there's the what's called the involuntary treatment officer, who is, hey, I'm the home plate umpire. I'm coming in the middle of the night. I've investigated, pulled all these pieces together, and here is the reason I did so. But I can refer to the reports of the family, but I can't testify to that because that's hearsay. So the family member or the police officer needs to come in and speak to the judge from their lips to the judge's ear, and that becomes the evidence piece. So let me outline. So here in Washington State a few years ago, it switched from a 72-hour initial detention to a 5-day or 120-hour initial detention. And so here's the process. So you can think of it as as a person's driving down the road and they swerve over the center line, and that is what gives a person, the involuntary treatment officer or the county sheriff or whoever, that gives them the reasonable cause to stop. No, wait a minute. How does that go? It gives them the cause to stop a person and investigate. So it's like, okay, sir, where's your license? Where's your insurance, and registration? And in that investigation, and that's basically, so there's the community piece that says, hey, a county sheriff, a law enforcement officer can say, look, there's something happening here. We need to investigate. So they'll pull the person over and bring them into the ER. Hey, you need to be in the, we need to get you in front of somebody that really knows this stuff. And so that's the initial sort of contact. And it can be from family member reports, police reports, the person's, walking around talking to themselves, talking to squirrels, all kinds of stuff. So that's the first kind of contact. And then they come into the ER, and ideally, the ER doc and the social worker go, oh my gosh, this person needs to be in the hospital. And the presumption is that they're voluntary and they recognize and are able to make a decision. And so there's no reason to get an involuntary person involved. So if the person goes, yeah, all kinds of stuff have been happening, I'm off my medications, yeah, I'll go into the hospital, boom, great. So the ER doc or social worker can basically advocate and get them into an available voluntary psychiatric bed or unit. But if the person says, no, I don't need to, or I don't want to, or they don't even understand what is happening, then, and there's enough concern about, geez, the ER doc says, man, we just can't let this person go, So they call in somebody like me, the involuntary treatment officer, to go, okay, I am the person of last resort. I'm the home plate umpire. It is my determination, my responsibility to figure out, can this person go home or, go wherever, they're free to go, or do they might meet the criteria to be detained? So then the ER doc or social worker calls in me. They have the special way to get a hold of us. And so we come in at, all hours of the day. I often work the night shift. And I get called in at 2 or 3 o'clock in the morning or whatever. And so then I come in, I take information over the phone, I come in, say, hey, where's the reports and all the paperwork and stuff like that. I review that and then go in and introduce myself, read the person their rights, Mirandize them, let them know the investigation is under the civil law, it's not criminal, and that my role is to basically be the home plate umpire in this situation and determine whether you need to be detained, you're willing to go in instead of being detained into the hospital, or we can figure out something else that is appropriate and reasonable to do. And so generally it's thought of that is once I read the rights and arrive at the hospital and do my thing, read the rights, then that starts an investigation period of however long it takes, in a sense. And back in the day, it pretty much, hey, you got to be starting that evaluation within 12 hours. Now it's 2 hours after you've been contacted or requested to come in. And you have to be finished. Back in the day, it was be finished within 24 hours. Now the target is 6 hours. And so during that period of my investigation, basically the person is temporarily detained. They can't leave. Once I read their rights, they become my responsibility. The investigation is my responsibility until I figure out, okay, this is what's happening. And so that can take hours. It can take phone calls, a ton of phone calls. I think my record was like 67 phone calls on one case. I've certainly gone 2 days in an investigation, meaning I'm there in the middle of the night, and because I think there's resources available, but because it's the middle of the night, I'm not getting people to pick up phones or talk to me or anything, and so I put my investigation on pause and say, look, it's 2 o'clock in the morning. We're not making it any place. I can't talk to the people. Family members aren't calling me back. The officer that brought them in is now off duty. I don't have the report yet. I just have report, verbal allegations that this and this happened. So I can put the investigation on hold until 8, 9 o'clock in the morning, and come back in the morning and take another run at it with the idea that I'll have better communication. I can talk to resources, reports, and figure this out. So there's that piece. And so once I make a detainment and say, no, the person is going to the hospital, and they're going under my authority because they really don't have the wherewithal to engage voluntarily, and they're not willing or incapable of making that decision. I'm taking responsibility for themselves as a representative of the parens patriae kind of idea of where the person's not able to take care of themselves. I am the where the rubber hits the road in that concept. I am the person representing that idea that the state then takes care of the person if they're not able to take care of themselves. So then I place them in a involuntary treatment bed someplace. And like here in I'm on the western side of the state of Washington, and so it's basically calling units up and down the I-5 corridor, looking for beds and stuff. And certainly you try to get the person, find a bed for them in their community, and if not, the next nearest community as close as possible. There was a time when we would send people, 400 miles across the state, and they didn't really have access to their community, the resources in their community, to the family and stuff like that. And that does occasionally happen. It used to happen more, but now we really try to keep people close to their community or within their community, where a case manager or a therapist can give them a call or come in and see them or talk to the treatment team and that kind of thing. So during the initial, so now we're into, I've detained the person, and within 5 days, excluding Saturdays, Sundays, and holidays, so it could range up to 7, 8 days that the person is detained into a bed. So during that 5 days, then the next period is really the inpatient evaluation and treatment phase. Primarily, it's the investigation of that. So then the psychiatrists, the psych nurses, counselors, therapists, psychologists, neurologists, lab work, all that stuff is done during that first part of their involuntary stay. And it's basically they're taking a look at the person and going, what is this? How can we help? What needs to happen to stabilize the person? And during that time, ideally, a person gets some medications or feels more comfortable, gathers their wits on or off medication, and they go, oh my gosh, my bad, I'm willing to be here. And so the inpatient treatment team can then basically, they have the ability to cut the person loose. They can say, no, this doesn't work for us. This is not a psychiatric case. Maybe it was a case of intoxication, or a case of perhaps a person being, in rare cases, something like septic, or maybe there's some delirium, dementia kind of stuff, so that's more of a medical or a containment issue. So they can go, no, we're going to roll this person over to a medical bed. They don't need the psychiatric bed. Yes, we'll send in the psychiatrist as a consult. They can be on a medical bed. The psychiatrist comes in and does a consult with the medical treatment folks, and they figure it out from that way. And that can be a voluntary thing, or like I said, they can cut the person loose, they can allow the person as a voluntary, or they make the decision, geez, the person is getting better, but they need more time than the 5 days. And so at day 3 or so, 4 maybe, they then put together a petition, which is merely a request for a hearing for 14-day commitment. And so the theory there is that between the mental health court liaisons as an independent evaluator and somebody from the inpatient treatment team, being either usually a psychiatrist or a psychologist, or maybe even a psych ARNP type person, is the representative from the inpatient treatment team, and they think the person needs to be in the hospital longer, that the person's not willing to be there as a voluntary, so they request a hearing in the form of a petition. And so the petition needs to happen before the end of that 120 hours time frame. And then at the hearing, there's 2 phases. I know you're probably glazed over by now. Hopefully I'm almost done here. So there's really two phases. It used to be the first phase was, did the involuntary treatment officer have a good case or have the evidence to do the initial detention of the 120 hours? And then the second phase is, now the inpatient treatment team argues for the case that the person needs to continue to be in the hospital for up to 14 days, and requesting the court, the mental health court, to make that order or make that determination and so order it. So sometimes in that process, I've had a few cases where I was the mental health court petitioner, and it's kind of independent, but also working with the psychiatrist or inpatient treatment team. If one or both of us determine, no, the person doesn't need the 14-day commitment. If one person says that, one party says that, then it's a no-go. Or if both agree, no, it doesn't need to happen, it's not proceeded, and then there's arrangements to be made for the person to be discharged, to follow up with outpatient treatment and all that. But if we both agree, then the case moves forward, and a petition is written and signed off by the psychiatrist and by the court liaisons person. And so those two are the co-petitioners for requesting for the hearing. Now, back in the day, hold on. Back in the day, the whole, oh gosh, I lost it now with the phone. Sorry about that. So, oh, okay, I know where I was going. Back in the day, you had the two phases of the hearing. One, if the involuntary treatment officer had enough reasonable cause to detain the person for the initial 120 hours. These days, because I don't know, it's just kind of evolved, but I suspect it's probably judicial efficiency on one hand. On the other hand, is like, because the person has been detained by somebody like me, it's already happened. It's a fait accompli. And so, since that happened in the past, we're not even going to hear that. Let's just presume that the involuntary treatment officer detained the person and did so in good faith and without gross negligence. And so we're not even going to hear that. We got, 8 cases in front of us or 5 cases in front of us. We're not going to argue about the initial 120-hour detainment. Let's cut to the chase, and the person's been here. Let's move on and see and hear the case for the 14-day commitment. So that's sort of how things have evolved from my understanding. And it's been a few years since I've been a court liaisons person, and I was fairly well acquainted with it, because I had been the fill-in, the substitute person when the court liaison person was sick or on vacation or something. But it's a very interesting little piece that most people don't have access to. So after the 14-day, towards the end of the 14-day commitment, then there's another hearing that can be held if so deemed or so requested by the inpatient treatment folks, and along with, again, the court liaisons, for what's called a 90-day commitment for either more restrictive, meaning remaining in the hospital, or lesser restrictive, meaning that they could have a 90-day lesser restrictive court order, which means they're free to go back home, but they now need to take medications, refrain from drug and alcohol abuse or use, and meet with their psychiatrist or their outpatient treatment team. However, the outpatient treatment team basically deems is appropriate. So that could be once a week, that could be once every 2 weeks, or once a month. This is a 3-month, 90-day kind of thing. And so you have inpatient, a more restrictive order, or a less restrictive outpatient kind of thing. And in that, basically the idea on the outpatient side, if the person is going to their appointments, to their groups, seeing their therapist, taking their medication and all that, great, no harm, no foul. But if they start missing or they deteriorate in their functioning ability, then this order allows the treatment team to say, look, involuntary treatment officer, we're concerned. We want you to evaluate the person and get them back into the hospital because they're not abiding by their conditions, or they're deteriorating, they're abiding by their conditions of the outpatient treatment order, but they're deteriorating, so they need to be back in the hospital. And so that's the basic kind of thing. And that process of bringing a person back into the hospital on order can be triggered by police reports, by family reports, by reports from the case manager or psychiatrist or whatever. It can be a violation of their conditions or they're deteriorating. And then again, that whole piece is, there's some subtlety there in that back in the day, whether the person was revoked on that order, revoked back into the hospital for up to the remaining of the 90-day order, right, remaining days of the 90-day order, that was kind of left up to the involuntary treatment officer to determine if that was clinically appropriate and an appropriate intervention to happen. And that is still somewhat the case, but due to some subtle changes in statutes or laws here, certainly the treatment team or family can write a great piece of evidence, and you know, if folks really wanted to do that, I can share that too. But you could basically tie the involuntary treatment officer's hands by writing a great report and saying, look, here's the conditions that aren't being met, and here is how they're deteriorating, and they're not, you know, following through on their outpatient treatment. And so there's been more weight given to that recently, in the hopes to get the person in the hospital before they hit bottom, you know, so we can, and the whole idea in the overall thing kind of is the whole idea, the earlier the treatment, the earlier the intervention, the better, because they don't deteriorate or hit bottom. You can save them before they hit bottom, and intervene, and so they don't quite hit the bottom, and it's quite the wreck. So then there's the same thing after the 90-day. Then there's the 180-day order, either more restrictive, or, which is pretty rare these days, just because we just don't have the inpatient bed capacity, and there's more people and all that. So oftentimes, then the 90-day, towards the end of the 90-day, you petition the court to have another hearing for 180-day commitment, either outpatient or inpatient. So, gosh, I think we're rolling up on about almost an hour. So, that's the first piece. Hopefully, I didn't bore you too much, but I wanted to present the overall picture, the big picture, and then how it comes together in the middle of the night. And the whole, I think one of the most important things to understand is a person's on the spectrum from outpatient, voluntary outpatient, to involuntary inpatient. And there's a lot of steps in between, or a person's acuity level, their level of presentation, and it can so you want to match the appropriate treatment to the clinical presentation. And in this whole thing, sort of the involuntary treatment officer wears two hats. One hat is you can look at it as an advocacy role of, hey, I'm trying to help the person, help the community, and the family. Let's get something done before it really hits the fan, on one hand. On the other hand, there's a duty to protect the person's civil rights. Here's a little interesting side bit about that. You know, I'm the involuntary treatment officer. I'm your friendly little person. I can come up and knock on your door and say, hi, I'm Tim, the neighborhood involuntary treatment officer. Can I talk to you? Now, I'm at your house or a place of work. You can shut the door and say, no, I'm fine, goodbye. I'm closing the door. Now, I can't force that door open. I can't force the evaluation to happen without you weaving across that line. But if you have woven across that line and there's reports and there's enough substantiation to do so, I can put my foot in the door and say, oh no, we got to talk. Okay. And once that happens, and back in the day, I used to do these outreaches, or I'd go to people's homes and stuff, or wherever they were. If they were camping out in the woods, I would often go either by myself or with law enforcement, county sheriff or local police, and we'd do these out in the field. And back in the day, I could detain somebody from the field and put them in the hospital. These days you can't, because the person has to get medical clearance and all that. But then when that was all done, I mean, I'd evaluate and say, okay, you're going to the such and such psych unit over here a few miles away. When I basically made that decision and got the person on the medic thing, you know, the fire department, medics or whatever, load them up on the ambulance, I would have already told the hospital, hey, this person's coming in, I'm detaining them. But as soon as that was done, I could tell no one what happened. Where they went to or anything like that. And so for some people, you know, hey, that's a big violation of civil rights, and I can see my way through to that, because in places, certainly, you know, the historically political folks that were out of favor would get picked up by the Stasi or the SS or the police and just disappear. Well, in some ways, this work also has a flavor of that. And so back to the advocacy is our job is to really also protect a person's civil rights. And so that can happen in a number of ways. One way is I've certainly had cases where let's say granddad has worked his entire life, been a great upstanding member of the community, and now, you know, he's either had some stroke or dementia, Alzheimer's kind of stuff, and he's not doing well, and he's in his own home, and just, it's a wreck. It's dangerous. He's leaving on the burners on the stove and what have you. Well, there's certainly cases where family members come in and say, hey, we want dad detained because he's dangerous and stuff like that. And granddad really needs to be in a new place or a different place. But for the most part, we haven't done anything about it because we don't know what to do. We want you to detain him. Well, yes, he needs to be in a safe place. But does he need to be in an involuntary psychiatric unit? Because here's the deal with the whole, what is called legal lesser restrictive. If I detain granddad into a psychiatric unit, then the family, which may not have all the best interest in dad, can then go to civil court and say, look, dad is in the hospital. He can't take care of his affairs. We want to get control over granddad's assets, and maybe he owns a few thousand acres of farmland or something like that. Well, that's a great piece of evidence for the family then to take to basically civil court and have him declared incompetent, and then they can be assigned guardianship of his financial affairs and estate and stuff like that, because the presumption is that granddad is incompetent. And so there's all kinds of little nuances like that where as an advocate, we're also responsible to protect that person's, that person's ability to live their life, control their life how they see fit. And the interesting thing is, with these cases, often, and I've had these kind of things, in the middle of the night, is like, hey, I understand your concerns. Here's the thing: if I detain granddad, where the hospital is going to burn up, $10,000 a week in his estate, and they go, oh my gosh, I thought involuntary was the state was going to pay for it. No, the state's not going to pay for it if the person has those assets available. So the point is, it's for me, I have often found in those cases, you're also sitting down with the family and having, hey, let's talk about what's happening, what will likely happen, what you folks need to do as a family to get your granddad the help that he needs, a place where he's safe, and also understand how we have to respect his estate and his sovereignty in a way, even though he may not be aware of it. So, but it's often a great interaction to have with the family in the middle of the night. So that's just an example of how seemingly you have an involuntary mental health evaluation then kind of change into this whole other discussion about the care and the long-term needs of a family member. This can also apply to a person that maybe has some mental incapacity, perhaps from Downs or autism. They're on the autistic scale, and they're now aging out of the school or the children's services, and now they need adult services, but because they're 18, they're basically responsible for themselves. And so then the discussion is, well, there's needs to be guardianship of the person's finances or the guardianship of the person's body, or both. So There's a lot of those kind of things that can happen in these ITA investigations, which are wide ranging, which is if you have concerns, whatever they are, the best thing is to get a hold of somebody that does this all the time and knows the local resources, the services, knows who's who. Oh, you need some guardianship, elder guardianship kind of work. They know the attorney that specializes in that, or the social worker, or all kinds of stuff. So we've run on to an hour, and it's flown by. So the next piece is I'm going to actually dive into the process of how this all happens within, anywhere from a few 20 minutes to sometimes 8 hours of that process of that actual evaluation and what goes into that. So that will be coming in another video. I would love to write this down, but as you can tell, there's so much there, and I think this is a more efficient thing. So thank you, and I look forward to doing the next one here. I don't know exactly when that is, but this is going to fall under the mental health piece of the blog. So if folks have questions or stuff, email me, make comments and all that, I'll be, that helps me to figure out maybe where to focus or questions and stuff. All right, thanks. Have a great week. Bye.